Good morning. This is every time I. Good morning. This is the Senate Judiciary Committee meeting regarding both youthful offender and raise the age. And this morning we're going to hear some proposals from various departments as well as advocates for some changes to the raise the age and youthful offender law. So we're going to kick off with Jennifer Pullman, Executive Director of the Center for Crime Victim Services. Jennifer, welcome. I believe you submitted some documents, and I don't know, Mike, how you get those on the screen. It might be helpful to see the documents on the screen. Jennifer goes over her testimony.
I could share them from my screen, or I could make each witness a co-host so that they could share them from their screen. I'd prefer the latter so that I can do it.
Jennifer?
I've never co-hosted.
Well,
I can, let's see.
you may admit Senator White, by the way.
Let's see.
Good morning, Senator White. So would it be easier for Mike to do it for you, Jennifer?
It might be, just in the interest of time and using the committee's time well, it would probably take me a couple of minutes to figure out that function. I apologize. I am still every bit the dinosaur that I was before I turned 50.
Senator Sears, I could do it if Mike, if it would free you up, you could make me the co-host, and then Jen, you could, as it goes along, if you could say, hey, move to the next page or whatever, I'm happy to do that for you.
Okay, thank you. And I certainly hadn't planned, given everybody's the need for time, to walk through every single bullet. I have spoken at length with Jessica Barquist and also with Evan Meenan, so I was going to focus on a couple of specific areas and then defer to them on others.
Eric, I'd appreciate that. And you are a co-host now, so if you hit share screen and have the document up on your computer, you should be able to roll through it.
Great. Well, I'm just going to pull the document up. Give me a moment.
Thank you.
You bet.
Thank you.
Sure. All right, we're making progress. All right.
Morning, Senator White.
Good morning. I would have been exactly on time, except that in Rutland, where the railroad track crosses Route 4, we waited for the longest freight train to go across and then back up again. So, but here I am. Thank you.
Good. Thank you.
Is everyone seeing that screen?
Yep.
Yep.
Okay.
Get ready, get started. Good morning, everyone. For the record, I'm Jennifer Pullman. I am the Executive Director of the Vermont Center for Crime Victim Services. And again, I want to thank you for allowing us the opportunity to continue to discuss the various proposals and discuss the various issues that the state is looking at when we're thinking about whether it be young people, whether it be delinquencies, raise the age issues, or youthful offenders. And so we are grateful for that. And we continue to believe that a system that's focused on the rehabilitation of a young person also can be one that looks at how we can support victims and address reparation as well. We don't see them as mutually exclusive. We see them as aspects that can exist in concert. And while certainly our systems must take account of the age and development of a young person when they have caused harm, we also do think it's important to acknowledge that simply by virtue of the age of the individual, that the harm that the harm that's created is no less. But we do think that while victims and survivors might disagree in some aspects about what justice might look like for them, there are three main areas that we've highlighted in our statutes and that we also know that are important to victims and survivors, which is the opportunity for information, for notification, and to be heard. And we think that our proposal and some of what else is offered is really looking at how we can honor those three tenets, as well as creating a system that recognizes the developmental age and processes that a young person is experiencing. We do support, and I'm only going to speak, as I said, to a few things on this proposal because we've been in concert on this whole process with the network and with the state's attorneys, and I will defer to them on some aspects. But I do have a couple of important areas of focus, especially as they relate to the center and the programs that we are responsible for putting in place for victims. The first is with respect to the Victims' Compensation Program. I'm sure many of you know that not only is the center mandated to, again, establish that program and to provide it, but it is a program that pretty much relies on federal funds, but also special funds to be able to provide some compensation, some reimbursement for uninsured expenses that a victim suffers as the result of a crime. And we're able to do that fairly quickly. Those losses might look like uninsured medical expenses, counseling, crime scene cleanup, funeral expenses, lost wages that occurred due to sickness or some other relationship to the crime. And our concern relates to how we can do that if a record's been sealed. And there is some recognition and some sort of a carve out for us currently under 33 VSA 5119 subsection I that allows us to still have access to victim information for purposes of compensation. But the problem is that we need something more. We rely upon an affidavit of probable cause. So when we're looking into whether we can provide some reimbursement for expenses, we do need to know, we look at that affidavit. For example, if it's for uninsured medical expenses, we need to see in that affidavit that there was some documentation of the injury, or whether it might be relating to, sometimes we do some security changes so that if there's if window locks were broken, let's say, then we will look at that. So those are, or a cell phone was destroyed. We look at that when we need that affidavit. We absolutely do not need any information about the individual that was alleged to have committed the act, but we do need to look at that affidavit. So our suggestion was to simply add on to the current language in 33 VSA 5119, an authorization that the compensation program will be able to receive a redacted copy of the affidavit for the sole purpose of verifying expenses within our statute. So that would allow us to be able to, a few years down the road, a victim may not think that they need counseling, but a record may be sealed and then they may be coming to us for support with that. So that would allow us to be able to do that. With respect to the restitution program, again, as this committee knows, we are responsible for administering that program. One of the things that we've found is that we really do need a restitution judgment order in order to be able to pursue collection at some point in time. There is a current bar that prevents us from doing so until the individual has turned 18. But without a restitution judgment order, again, we are prevented from doing that currently. The practice is that sometimes either the order is not issued because it's just sent over to a barge program or diversion or some other body to work with the individual to do that. And we don't want to supplant that because we recognize that that's a really important role that they serve, and we're not interested in that. What our hope is that we would have a restitution judgment order that would be issued in conjunction, put on a probation certificate, let's say, so that we could in fact pursue that when the individual does turn 18. The other piece is that we can't advance funds out of the restitution fund to support victims without that order. So when this body had put in place the restitution unit many years ago, the intention was to be able to find a way that victims would not have to wait years to get restitution, but that we could actually use the fund to be able to support victims right away for certain losses. So we would ask that be a piece that committee considers strengthening that restitution judgment orders shall be issued. And again, not looking to supplant the important work that barge and diversion and other programs are doing. Finally, with respect to restitution, we would just like language that would clarify that if a record is sealed, that that doesn't stand in the way of our ability to enforce this civilly. It's quite clear in the other statutes that that this has no criminal justice implications, no implications on any delinquency process. It's a civil order, but we would just like it clarified that we still have that ability to move forward on a sealed record in terms of just the purposes of collecting restitution. With respect to information pre-charge, just like to think through how that might work.
Jennifer, I have a question
Yes.
before we go to the next stage. About 20 years ago, the legislature passed a bill that would make parents responsible in some cases for the acts of their minor children in terms of victim restitution. There was a case where in my district, a young man who was starting his own construction business had a lot of equipment destroyed by some teens. And at the court hearing, the teens kind of laughed and their parents laughed. There's no way you can get us in that. So I'm curious how that would impact as well if the parents are providing the restitution.
Currently, we are holding off on cases until an individual is 18 because there are other provisions in statute that we are viewing as standing in the way. If barge or diversion or some other process or DCF is collecting it, which they very well do, and then they are sending that on to us. But as far as us as a unit looking at, we do tax intercepts, different things of that nature. We don't act on that, but we do rely on our partners to collect restitution. But I think that's another important piece too, is that we're finding that without the RJO, individuals who might have been discharged from probation or from diversion or from another program are still being held onto in terms of the caseload because, for example, DCF probation is looking to collect that piece. And we see that as something that if individuals who shouldn't be on probation anymore, but for the fact that they haven't paid restitution, we just think that getting them off of that process would probably be beneficial to all.
I don't disagree. I'm just
where our unit is reading it that we are to basically take a hands-off approach and rely on others to collect until the young person turns 18.
Yep. Okay.
I do want to think about, thank you. I do want to think about the whole piece around information pre-charge. This has come up even in my previous position. Advocates were raising to me a concern about the lack of information that can be, what can be shared with the victim before there's actually a charge. And this has happened in a couple of serious cases. One advocate brought to my attention, it was a sexual assault and the victim was not able to receive information on that for a few months. And when victims are in the dark around that, it's a pretty scary situation. And whether or not we want to think about perhaps introducing something that would mirror what's currently in 13 VSA 5314 that applies to adult victims, or that applies in criminal cases, or maybe think about importing some language that I kind of borrowed from S107, which even though it was vetoed, had passed both the House and the Senate, but some limited language that you'll see there around leaving it to the discretion of a public agency. So we would just ask that the committee consider thinking about ways that we could provide some more upfront information for victims in these crimes. Moving forward, I think that some of these pieces are just about maybe clearing up some inconsistencies. I do think that there has been a concern that perhaps the court should be allowed to have discretion to release other conditions of release to victims, and as they might pertain to them. So just allowing space for the court's discretion. I think, and again, moving down in terms of the right to notification around probation and also termination of probation, there's an inconsistency currently wherein delinquency matters that would have involved a listed crime. If the individual is an adult, a victim has the right to know the conditions of probation, but that's not spelled out in YO cases, nor are there pieces around the termination of probation. And in speaking with DCF and also in looking at the 2019 report around the implementation of Act 201, there is no bar internally to them being able to do that. So if we could just make that more explicit, I think that would be helpful. With respect to having a support person, we feel it strongly that if a victim, especially where they're ordered to attend a hearing, whether it be by subpoena, whether it be a deposition, but that they should have access to at least a victim advocate to be present and have that person present. Again, it's when we're thinking especially about our young victims, I think that the idea of them going into a courtroom and not having somebody that they can have with them is very concerning. And so we would ask that the committee think about at least making sure that the person, the victim, has access to an advocate to be present in that hearing as well. And California goes so far as to allow the victim to choose a support person.
Yeah, Senator Sears, may I ask a question? So, Jennifer, I guess I'm confused because I thought that anytime it would be the state's attorneys that would be bringing the charges, and that anytime there was a state's attorney involved, there was a victim advocate involved.
There is, but I think this is one of those pieces that, again, seems to be consistent throughout at least the portions I'm talking about, where practice varies because it's not explicit. So some advocates that I've spoken with over the years are not able to feel that they're not allowed in the courtroom. So certainly, yes, they are working with the state's attorney's advocate throughout. And Evan could probably speak to the, Evan Meaning could probably speak to this as well, but yes, they do. It's just how different courts are interpreting what is allowable in a delinquency matter or any matter that involves a young person. So again, it's making something, we're asking for something to be made explicit in order to improve the consistency of practice.
Thank you.
Thank you. There's more pieces around confidentiality below that you'll see, but I'm going to defer to Jessica Barquist on that so that I can, again, account for other people's time. And I know that she's going to speak to that. The piece below you'll see with respect to 33 VSA 5117A is just to tweak that little piece wherein it refers to a delinquent act that would have been a felony if committed by an adult, and ties a victim's access to identification information regarding that young person to whether or not it would have been a felony. And I would ask that that be cleaned up because we tie everything with respect to victims' rights, especially in delinquency cases, to whether or not it would have been a listed crime. So it's just a minor tweak in our eyes to bring that into consistency with the rest of our statutes. Moving forward, we had a piece that, again, I'm going to defer to Jessica Barquist on with respect to attendance at hearings. I'll certainly be available for the rest of the day, watching this whole piece for any questions, but I will defer to Jessica in the interest of time. And also moving on with respect to the deletion of the words upon request, which would be the piece that triggers the victim's right to notification around a young person's release from a secure facility. We would ask that that piece be struck. It's interesting that that seems to be the only area with respect to any of our statutes concerning victims that requires a request. And especially when we're thinking about victims being involved in these cases that are already kind of murky with all the confidentiality issues and who's actually working with victims, that for them to try and figure out who that request should go to, we just think that should just be an automatic right that victims can opt out of. Moving forward, I'm going to just skip down briefly and touch upon that whole public safety discussion down in 33 BSA 5584. I'm not going to belabor it because I know that that's been raised at length in previous hearings. I do think that, again, there is one important piece in that you all were have provided within 33 VSA 5288 that a victim has a right to be present. But I don't think, again, I'm hearing that that's not something that necessarily is consistently recognized by courts and even by state's attorneys. So perhaps if there is a decision to amend or further define what is meant by public safety, perhaps within 5584, this committee might consider adding a cross-reference to 5288 or in some other way. Oh, 5588, sorry about that. Or in some other way, recognizing that the victim's voice should be heard in that discussion. Two other pieces of cleanup I'm going to suggest, and I think that would again help to establish some sort of clarity and consistency in practice, is with respect to victims' rights provisions in Title 13. We have two carve-outs for victims when we're establishing general rights with respect to notification and information. And then there's a clause within that says, other than victims of acts of delinquency. When these statutes were created, this was before victims were provided with some basic rights in delinquency matters. And I think that the fact that those provisions still exist does establish an inconsistency and some confusion. And I think looking at what we currently do have in statute, we question whether or not that needs to actually be there or whether it's just more confusing. And finally, I just want to wrap up with a recognition that back in that 2019 report around the implementation of Act 201, that it was noted that the department, that DCF does not have the current organizational capacity that has been built into DOC or the state's attorneys and sheriffs, wherein the state's attorneys and sheriffs, as Senator White referenced, all have victim advocates, and the Department of Corrections also has victim services specialists that serve throughout the state. So they are that liaison, those point people that victims can work with. And in that report, it was noted that DCF currently did not have that capacity. And certainly, if the federal funding were different, I would like to be here saying, you know, the Center for Crime Victim Services, as we do, would be looking to support positions in that regard. But for us, that's going to be a priority moving forward and thinking about our role and how we can do that. But I do think that it needs to be noted that we're asking DCF to do a lot more and thinking about that, again, moving forward as far as how we can support the department in building that capacity. So I'm grateful for the time that was for this committee, and I will be remaining on the call and day throughout. And just looking forward to having the continued opportunity to work with you all on this. And if you have any questions or if you want to hold questions, I will be remaining with all of you for the day. Thank you.
Dick, you're muted.
Yeah, I know. Life of Zoom where you mute yourself. Any other questions of Jennifer? Thank you, Jennifer. We'll try to go over these. We're next going to hear from Jessica Barquist from the network, who has some similar statements. So Jennifer, Jessica, please feel, I'm sorry. It's Monday morning.
That's okay. Good morning, everyone. Happy Monday. For the record, Jessica Barquist, I'm the policy director of the Vermont Network, and I will try and keep my remarks pretty brief. Last time we met, I was able to express our commitment and support of the Raise the Age policies and also raise some concerns with this committee regarding the victim access to these court proceedings, the notification of our treatment conditions and changes in status, and that interpretation of confidentiality that's imposed on victims. And so in developing this proposal, we were lucky enough to be able to work really closely with Jen Pullman from the center and also consult with Evan Meenan with the state's attorneys. So the network fully supports the proposal from the center, and we're just really grateful for Jen and her thoughtfulness and collaboration here. So I, as Jen kind of mentioned, am going to focus our our suggestions on some language changes that will really allow victims to more fully participate in the juvenile process. So we focused our proposed suggestions in 33 VSA 5234, which is the statute that deals with delinquencies of proceedings involving a listed crime. And because the delinquency proceedings are already distinguished between listed and non-listed, we felt like this was the best place to make those changes as it relates to domestic and sexual violence cases, because most of those cases will be encapsulated in this. And so really the primary change here is in section 3. And we suggest that this language mirror what is in the youthful offender statute in 5288. So I actually just copied that language right from the youthful offender statute and put that in there. And then, like Jen also suggested in section 4, we suggest deleting the upon request to make that notification automatic. We also believe that all of this victim notification should be opt-out rather than opt-in. Jennifer also mentioned the importance of having the victim have access to a support person, whether that's the victim's advocate or a lawyer. And we also support this and suggest that that change needs to be made in 5110, as this is the statute that references who is allowed in the courtroom during juvenile proceedings. And so in here, we just specifically suggest adding in the victims, their counsel, and designated victims advocates to section B. And then really the final change we are suggesting is also in 5110, subsection C. And this is where we are attempting to address that confidentiality issue where victims are told that they cannot talk about their experience with anyone. And so we suggest here that, that this language really be clarified to explicitly state that they can talk about their experience or name their victim, but what they can't do is talk about the details of that court proceeding. So they can say, person X assaulted me, but they can't say, person X assaulted me and is now in juvenile court as a result of that. And this is what's happening in juvenile court. And so this will really, I think what we're trying to get here is that balance that we talked about last time between the confidentiality that is so needed in these proceedings and also that safety for victims, so that they do come forward with these charges and are engaged in that process. And that was really all I have for you. I know that Evan also has some victims related stuff that he's going to talk about as well.
May I ask a question, Senator Sears? You're muted, but I assume you said yes.
Please do.
So I do understand this, and I'm thinking about when the definition of victim. So, and this isn't something that would get necessarily to even to court because it might go to diversion, but maybe the person has already used up his diversion or something. So about 2 months ago, about 5 mailboxes on a road in Putney were smashed, just demolished. And they found the person who did it. Would all 5 of those people who had their mailboxes smashed have the right to go to the juvenile proceedings? I mean, that doesn't make any sense to me, but they are the victims.
Yeah, so my expertise is the domestic and sexual violence crime, so I will let Evan speak to that. But my understanding is that that probably wouldn't be a listed crime.
Well, so this only refers to listed crimes.
This would only apply to listed crimes, yes.
Okay, that helps a little bit. Thank you.
Yeah.
I'd be a little concerned about your proposals in terms of where the allegations may not be true or may not be proven. Then what happens to this kid who has been talked about publicly, perhaps on social media?
Yeah, it's definitely a balance. And, it's a policy decision where that ends up. There is nothing in statute that prevents an adult victim from naming their offender or talking about it on social media. And so I think the challenge is that that expectation falls on our youth victims, but not on our adult victims. And I met with a victim's advocate who told me a story about a sexual assault case, in which in the proceedings, the defense tried to get sanctions on the victim for naming their offender on social media. And, the judge clarified in that case that it's really about the juvenile proceedings that the victim couldn't talk about. So I think it's just helpful for that to be explicit in the statute and for victims to know that up front, so that they can fully participate in that process.
In the case of Jack Sawyer from Fairhaven, which was quite noted all over the place, and his name
Was this me? Is this my internet or is it Dick's?
No, that's Dick.
Okay.
I
I
think
don't trust
Senator
mine.
Sears- I think Senator Sears froze
That's
up.
me asking the question. A case like Sawyer's, where the state attorney actually gave out the information, and it may or may not have been legal, but it was done. It was well known. He was treated as a youthful offender. We don't know how he was treated or the outcome, which is probably a good thing, but everyone knew about it. And one could argue there were thousands of victims because the community, every school child in that community was aware of what was going on, and there were, people were actually afraid. We had many groups come to the State House worried about it. So I'm wondering, where did you draw the line? Who a victim?
So can I go back and ask kind of a follow-up to that?
Well, I don't think, I guess
Oh, okay.
mine's more of a comment, but
And then
I don't know if either Jen or Jessica want to comment on that.
Yeah, I think that our thinking was that this applied to the named victims within the case. And really our intent here is to allow our youth victims, particularly when they've had a really traumatic experience, to be able to talk to their parents and their therapists and their support people in their lives without fear of being charged by the court for doing so. I think that sets up a precedence that will make it so that victims don't come forward when their offender is going to be in juvenile court. And that's not what we want to see happen. We want them to be able to access this support system.
I have no problem with accessing the support system. It's where you said explicitly clarify that victims may talk about their experiences or even name their offender publicly, but it's not lawful to say they were charged in juvenile or provide details about the proceedings. There's a difference, frankly.
because it does specifically say publicly. It doesn't say to your parents or your therapist. It says publicly, which implies that you can do it publicly. And I get my follow-up question on that is if we're really, for the most part, talking here about the Big 12, how many I'm just curious how many really egregious offenses or cases would be pursued in juvenile court as opposed to being moved to criminal court. And in criminal court, it's all open public record anyway. So are there tons of cases where it's really an egregious crime and it is one of the big 12 and it stays in juvenile court?
Yeah, I think Evan might be able to help me out a little bit more here. But so my understanding of this statute is that it would apply to all juvenile proceedings. So this would be for both delinquency and youthful offender. And really what I'm hoping to get at here is that that it's the same across the board between the juvenile proceedings and the adult proceedings. So if I was in adult court as a victim of sexual assault, and even if it went through a jury trial and my offender was found not guilty, there is nothing in statute that would prevent me from talking about my experiences or naming that offender publicly. And so that's the consistency that we're trying to create within this statute.
But the reason we did this is because the juvenile offenders are not the same as adults. I mean, that's the basic premise here, is that they, and if it's in adult, it's in criminal court, and so it is public. But the reason we suggested putting these in, and the reason they're in family court, in juvenile court, is because of the nature of the offender. Anyway, I'm not sure that consistency is necessarily a virtue to be pursued.
Thank you, Senator White. Are there any other questions or comments that Jessica, that you'd like to make? Okay, thank you so much for your testimony and for the written document. I definitely would agree with both you and Jennifer that we could make improvements in the victims' processes here. I'm not sure how far I would want to go, but I do think there's room for improvement. So I appreciate your testimony. Certainly victims should be taken into consideration and should have opportunities to gain support, be able to talk about support groups or therapists or parents. All right. The next witness is Marshall Paul, the appellate and juvenile defender with the Defender General's Office.
Thank you. Good morning. So instead of sort of jumping right into my testimony, I'll start by sort of jumping right into this issue around confidentiality, and specifically confidentiality around victims. We don't see this as actually being, what's been proposed so far, we don't actually see as being any sort of a change in the law. The law right now does not prohibit anybody from naming their offender or talking about their experience outside of the courtroom. It does prohibit people from speaking about what happens in the courtroom, or speaking about any court documents or any information that they learned in court. But the law does not prohibit anybody from saying, I was a victim and this is who did this to me. And in fact, it couldn't. I mean, that would be really a First Amendment problem, to the extent that the law can prohibit someone from talking about, an experience that they had outside of a courtroom, just out in public. To the extent that you can prohibit somebody from talking about that, you consistently with the First Amendment, you can't do it in a blanket statement. You can't just say all victims of juvenile offenses may not talk about their offenses. It's something that has to be decided on a case-by-case basis for really particular reasons. And frankly, it's almost unheard of that a court prohibition like that would actually be upheld. So Our office certainly has no problem with changes that would make that more clear if that needs to be made more clear. We also think that it may just be a training issue because as I said, we don't actually see this as a change in the law. We just see this as sort of saying something that's already said in the law in a few more places, which may not actually reflect the need to change the law and may in fact reflect a need to train people on the law. But so, with that, I'll kind of jump into the body of our testimony, which is that our office didn't submit a proposal of changes to make, but we asked to speak anyway. And that's because we don't see a pressing need to make substantive changes to either youthful offender or raise the age. We fully support many of the procedural changes that have been proposed. In fact, we support most of the proposals made by the center and the network in their testimony. We have a few little points that we would need to iron out, but probably 90% of what they've proposed we could support. A lot of it we don't actually see as changes in the law, and instead just sort of further clarification of the law as it exists. And we support many of the procedural items on the state's attorney's list. I mean, frankly, if it has to do with ensuring that victims receive notice of their rights, that rights are clearly spelled out, that we have consistency in practice across the state, or that the process of evaluating and transferring cases to the place where they belong is sped up and works efficiently, we can support it. What we don't support is changes that would actually affect the substance of these laws. We haven't seen evidence that that's needed at this point. We haven't seen evidence of any sort of systemic pattern of danger to public safety. We haven't seen any increase in recidivism. We have seen a lot of kids, including kids charged with very serious offenses, given the chance to get appropriate treatment and prove their commitment to desistance and then go into their adult lives without a criminal record and without, DOC supervision hanging over their head for many years. And that's been a real benefit for a real lot of Vermont youth. So, because of that, what we want to see is we're fully supportive of several of the procedural changes. We're fully supportive of the pause, putting the expansion of raise the age for 19-year-olds on hold. I mean, I think, frankly, even though every time I say that, it makes me queasy because I care a lot about this law and I want to see it go into effect. I'm just reminded over and over again what a tough time this is. I mean, I was just this weekend looking at emails from one of our big providers down in the southern part of the state, telling us that, kids who are in their care right now can't have treatment team meetings, can't go to court, can't do anything outside of the core responsibilities of their program because they just frankly don't have the staffing. Like they need all of their staff to staff the program as it is, and they can't afford to be sending staff to treatment team meetings, taking kids to court, working with kids at court. And, frankly, I hate to phrase it like this because I don't want to put words in anybody's mouth. But from our perspective, that's a crisis. I mean, treatment team meetings are how kids, they're the meat and potatoes of the process of moving kids through the system. And getting kids into court is always tricky. And so having any further barrier to that, is again a real problem. And so we do not want to see an additional stress placed on that system right now by putting the 19-year-olds in. As much as it pains me to say it, it frankly would be, probably just setting the system up for failure. And we don't want to see that. So we support the pause and, we support a real lot of the proposals that have been made both by the network and the center and several of the proposals made by the state's attorneys. And we'll certainly work in the coming weeks to, work with all of the stakeholders to identify exactly which proposals we have sort of consensus on and which ones there's more disagreement about. But frankly, I mean, I'll tell you that our office's position is going to be very supportive of procedural changes that are there to improve the system and make it function better. And we are going to be opposed to procedural changes that are there to address problems that we haven't actually seen evidence of yet. And with that, I'm happy to answer any questions.
But questions for Marshall? Yeah, just one question I guess I'm a little confused about in light of what you just said, in terms of public information, particularly about youthful offenders. They are treated as when an arrest takes place. Is that public information if it's a 19, 20, 21-year-old?
That is
Even
not,
if,
the answer is generally yes, that is public. That's not been entirely consistent. I think S-107 from last year
Right.
would have enforced some consistency around that. That was one of the problems that was identified in discussing S-107 was that there was really inconsistent practice. So I think right now practice is inconsistent, but generally when it's a youthful offender and the arrest is made, that is public.
and I hear anecdotally that some jurisdictions almost automatically approve youthful offender requests. Other jurisdictions don't. Is there any factual basis to that?
You know, I'm sure that there's disparity from judge to judge. It's not as if you can have 30-something judges and have them all act sort of uniformly in concert. I've certainly not seen any county where, you know, every single youthful offender petition is being approved. I do have some stats on that I'm sort of parsing out. You know, the statistics are really difficult when it comes to youthful offender, just in terms of how they are kept. You know, the judiciary is the source of the statistics, and there's certain statistics they keep and certain statistics they don't. So we're able to see some things and not others. And then there's things that we can see if we do a case-by-case review of all, you know, basically 1,000 youthful offender cases that have happened since the change. So I certainly have not seen a pattern like that. But if what you're, you know, so if you're asking, is there any county where they're just approving every single youthful offender petition, the answer is no. If you're asking whether or not there's certain counties where they're approving a lot more than others, I don't know that, but I wouldn't doubt it. That would be consistent with most Vermont legal practice, is that it's not consistent.
That it varies from county to county.
Exactly.
One other question, and that is the amenability to treatment. How do we figure that out?
So in general, I mean, that's generally.
How do you argue that if your client may or may not be, doesn't even know what he or she might be getting themselves into in terms of treatment? How do you counsel them?
So in most youthful offender cases, almost all of them, frankly, it's the juvenile's burden to prove that they are not a risk to public safety and amenable to treatment. And the way that they most frequently do that is by bringing in an expert witness, usually a juvenile or adolescent psychologist who has done some work with the kid, usually has administered some tests and some particular evaluations and assessments. And they talk about amenability to treatment based on the kid's sort of pattern. So they'll say things like, you know, kids who demonstrate this type of, you know, behavior and who have this type of stuff in their background usually respond well to this type of therapy. And that's what I'm recommending. They also might talk about if the kid has worked well in treatment before, like, for example, if, you know, when I've had kids who have been through treatment before and been successful at it, and then sort of fallen off the wagon for one reason or another, either they moved or they, you know, turned 18 and were no longer had access to the treatment they had access to before or whatever. We can use the fact that they were successful in prior treatment to show that they are amenable to further treatment. And then the kind of stuff that weighs against you is, you know, if you have a kid who was supervised before, like if the kid had a delinquency before and had a lot of violations of probation and really wasn't succeeding in treatment, that's the kind of stuff that'll weigh against you and say, no, maybe this kid's not amenable to treatment. Or, you know, frankly, the one that's very determinative when it comes to kids who are charged with more serious, quite serious offenses is whether or not they admit it when they're talking to the psychologist. You know, if they talk to the psychologist and they're denying it and saying, I never did that, the the psychologist will often say, yeah, that's a sign that this kid's not going to do well in treatment because, maybe if there was years and years and years available for treatment, we'd be able to work with this kid and get them to a point where they saw the offense for what it was and, we're able to work through it. But with the window that we have, maybe we can't do it. And therefore, this kid's not amenable to treatment. So that's the way we usually do it, is through the use of an expert psychologist.
Thank
May
you.
I ask?
Senator White has a question.
I have a question and I have a comment because, Marshall, it made me think of this. When you get arrested for a DUI, and a young friend of ours who was, I think, 16 or 17 did, and she had to go to the crash program, and it was like a catch-22. There was a question in there: do you have a problem with alcohol? Do you have a drinking problem? If you say no, you're in denial and therefore you need treatment. But if you say yes, you need treatment. It's a little bit of anyway, my question is, you did not oppose a pause, but I'm wondering, because we had kind of this discussion before, and the way I understand it is that the administration, I think is what Jay Johnson said, is that they would like a pause until the agencies determine that they're ready to go forward. And I know Senator Baruth, for one, had said, no, there might be a pause, but there's a definite date that's set by the legislature. So would you just clarify where you are on that?
Yeah, I think that we're supportive of a pause with a date. I think what we've been talking about internally is 1 year. We're open to feedback on that because, frankly, our main concern is the resources, and we see that, we see the resource problem through one lens. DCF sees it through another and might have more information. So while we might be flexible on what the timing is, we would want the timing in the legislation.
Thank you. That's an important distinction, I think. And I personally have witnessed the staff shortages. I run into the executive director of the program I used to run at the local Price Chopper Sunday morning around 8:30, and I said, "What are you doing here at 8:30?" He said, "I just got off my shift and I'm working." Here's a guy who hasn't worked the floor for years, being forced in there, and I understand that they're so short-staffed that the number of kids they can handle are not what they would normally want to or could. I know Commissioner Brown can speak to that, but those shortages, staff shortages, as well as COVID issues, are very real. And so I think it's completely understandable that we haven't been able to go as far with raise the age as we'd hoped at this point. There's no doubt in my mind that the pandemic has had a huge impact on the efforts that DCF and others were trying to put forward. All right. Any other questions for Marshall? Our next witness scheduled is Evan Meenan, a deputy state's attorney. He used to be with the Attorney General's office. He's now with the Office of State's Attorneys and Sheriffs. I get this title confused.
Good morning, everyone. Again, for the record, my name is Evan Meenan, and I'm a Deputy State's Attorney in the Executive Director's Office of the Department of State's Attorneys. Thank you very much for inviting us to testify today. We did submit a written proposal that we would like the committee to consider, and which I'm going to go over on a higher level this morning. The way in which we structured the proposal was, first we tried to outline some of the problems or the issues that we think we're starting to realize when it comes to delinquency and youthful offender proceedings. And then what we tried to do was lay out some either examples or some hypotheticals that illustrate those problems, and then identify some potential solutions that might be able to help address them. When it comes to the examples and hypotheticals of problems, I'm certainly happy to try and collect additional information to gauge their prevalence and see if there's additional examples. However, I do want to flag that the ability to get into more specifics might be somewhat limited due to the confidentiality provisions related to these types of proceedings. I did want to initially flag some things that the proposal does not include. The proposal does not contain a request to repeal or scale back, raise the age itself. We're also not proposing any sort of alteration to the opportunities for diversion referrals in either delinquency or youthful offender proceedings. And we're also not specifically asking to scale back or alter the opportunities for expunging / sealing records upon successful completion. And I say expungement / sealing because, consistent with some recommendations we've made in the Joint Legislative Oversight Committee, we would like to see a single system for sealing rather than a bifurcated or two-track system. I raise initially the things that we don't want to change in order to emphasize that the state's attorneys do agree that a rehabilitative process for certain aged offenders is a legitimate way to approach those cases. I also want to flag, at least preliminary, that the state's attorneys have had time to talk with some, but not all of the stakeholders that are interested in this conversation. And so, as indicated in the beginning of our proposal, we're happy to and would like the opportunity to talk with additional stakeholders about any concerns they have with this proposal or alternative solutions to the problems that we've identified. And that last part, I think, is very important because the state's attorneys are wedded to trying to find solutions to these proposals, but they're not necessarily wedded to the solutions that we've identified ourselves, even though we do think that these are viable solutions. And those additional conversations, we're happy to have them on a one-on-one level with stakeholders, on a one-on-one level with legislators, or even in the context of some groups that might be interested in this, such as the Juvenile Justice Stakeholders Group. Another thing that the department recognizes is that some of the issues that we've identified as being problematic are not going to be capable of solutions that can be quickly implemented. So we know that there's certain things that are probably not going to be accomplished before the legislature adjourns this coming May. Those types of problems include finding secure placements for all individuals aged 18 to 22 who might need a secure placement, because not all of those individuals do need a secure placement. Another solution that's probably not going to be easy to implement on a quick time frame would be rewriting chapters 51, 52, and 52A, which are the ones that relate to youthful offender proceedings. The department thinks that rewriting those chapters is a good idea because the way in which they've been written and amended over time has made them, in my opinion at least, very difficult to follow and easily access quickly. So for one example would be, I was trying to find the other day all of the separate statutory provisions that relate to the confidentiality of youthful offender provisions. You'd have to read 4 separate statutes that are not listed sequentially to understand all the confidentiality provisions related to just youthful offender proceedings. You'd have to look at 3 to 4 additional separate statutory provisions to understand the confidentiality provisions for delinquent proceedings. I think we can probably do a better job and get them down to a single statute or maybe 2 statutes in order for someone just to read in a single place what is and is not confidential related to these proceedings, as opposed to potentially 8 separate statutes. And that's just one example. And I flag this because I think, or in my opinion, and expressing this on behalf of the department, rewriting and reorganizing these statutes could in and of itself resolve some of the problems that we've been talking about. If they were easier to access, not only by the practitioners, but by victims, attorneys, and the children and families who are going to be subject to these laws, they may be easier to implement, easier to get some consistency, easier to train on. And some of the frustration that at least has been vocalized to the department may be easier to address without actually making some substantive changes to the laws themselves. However, rewriting 3 chapters in Vermont law, especially given the number of stakeholders who need to be heard on that issue, might be too big of a task to accomplish during the second year of a legislative session. And the department, for that reason, is willing to assist in that effort over the summer, whether it's working on its own directly with legislative counsel, or, for example, the Juvenile Justice Stakeholders Work Group. However, there are some problems that I think it could be possible to address this session. Excuse me. One of those problems has to do with aging out of jurisdiction. And the example that I gave in the proposal had to do with a youth who was recently charged with committing 2 different sexual assaults against 2 different juvenile girls in 2 different counties. And that individual sought youthful offender status. We don't know for sure quite yet because the matter is still pending, but it is likely that the rehabilitative services that are going to be recommended for that youth, if he's adjudicated a youthful offender, would last 18.5 months. The issue is that juvenile is only 18 months away from aging out of jurisdiction. From the department's perspective, if we're going to be creating and implementing a rehabilitative focused process for these aged individuals, we shouldn't have some sort of arbitrary age deadline that all of a sudden they go past and can no longer access those rehabilitative services. You know, at the last hearing that we had on this topic, 1 or 2 folks recognized that the age 18 was not necessarily a magic number. So why is that the dividing line all of a sudden for someone to be treated as an adult as opposed to a youth? I think you could make a similar argument related to these age out provisions. You know, why all of a sudden is a certain age the magic number where we're not going to, that person may no longer be able to access the rehabilitative services that we're deciding that could help address the underlying issues that led to this problematic behavior. So that from the department's perspective, as soon as someone is able to get into the system, they should be able to continue to engage with the system until they either complete their rehabilitative services or have their status revoked, for example, as a result of a probation violation. Another problem that we might be able to address in the short term has to do with some of the confidentiality provisions in law. And you know, the center and the network testified about some of those earlier this morning. And the department agrees that the issues that they've identified are real issues and that their solutions would help go a long way to addressing them. We have, our proposal might be slightly different, but I think it goes in the same direction. We're trying to do a couple of things in our proposal. One relates to the confidentiality obligations for the state, and then the other relates to the confidentiality obligations for the victims. When it comes to the obligations on the state, what the department would like to see happen is have a carve out of from confidentiality so that in certain circumstances, the state can rebut public misinformation about a proceeding. And this is the example, example number 2 in our written proposal. So in one county recently, we had a juvenile defendant who committed a crime involving sexual misconduct against the juvenile victim. The juvenile defendant was granted youthful offender status, and we're not saying that that was or was not appropriate. It's just they were granted it. And afterwards, the defendant made certain representations in the school and the community that the case had been dismissed or somehow resolved in a way that indicated that he did not engage in the behavior that he was accused of engaging in. And he made these representations despite the fact that there was very much still an active court case against him. The victim heard these representations and was living in the community, still attending the school. And because the state was not able to support the victim by acknowledging that, yes, this case is still pending, there's been no adjudication indicating the defendant did not engage in this behavior. The victim was left to try and refute those allegations on her own without support from the state. And the concern that we have is that if those types of situations become prevalent, or even knowledge of those types of situations becomes more prevalent, victims, especially juvenile victims, may be apprehensive about coming forward with allegations against juvenile offenders. And so the specific proposal that the state's attorneys would like to see adopted is to have some type of carve out that's similar to the one in Rule 3.6 of Vermont's Rules of Professional Responsibility. Now, that rule governs what lawyers may and may not say about pending cases. The idea being that these cases should not be tried in the court of public opinion. They need to be tried in court based on the evidence that's presented. And what the carve out says is that a lawyer may make a statement that a reasonable lawyer would believe is required to protect the client from the substantial undue prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. So basically, it enables lawyers to make very discreet statements in order to correct misinformation that's been made public, but not which they've made public. I think a standard like that could easily be adopted to address these types of situations.
Evan?
Yes.
Mr. Chair, if I might.
Yep.
Evan, I hear what you're saying. I'm just wondering, suppose you have a very aggressive advocate who takes this provision as your suggested change as a way to, in real time, continue to address every piece of information that comes out. Doesn't that take you down the road toward not playing it out in a court of law, but rather giving permission to go blow by blow in the court of public opinion? I mean, I know you said that they could issue a discrete statement, but discretion is in the eye of the beholder. How do you prevent abuse of what you're talking about?
I think there's two things that we could do to address abuse. The first of which is something that I think I think actually you, Senator, mentioned previously, which was, and I think actually I believe it was in this context, having some type of penalty for violating the confidentiality provisions related to these proceedings. And I think there's already provisions in existing law for that. So, for example, if a judge determined that the state made statements that went beyond this carve out, then that individual could be subject to a penalty. In addition, this is a rule of professional responsibility that's been on the books for a very long time. So any lawyer that violated that provision in the context of a juvenile proceeding would be subject to a professional responsibility proceeding that could include sanctions up to and including the loss of their law license, either temporarily or permanently. So as a lawyer myself, I would be very careful about what statements I did and did not make, and I would be paying very close attention to the second sentence of that standard, which requires any public statements made to rebut false or adverse public statements need to be limited to only the necessary information. And so I think that the potential ramifications from violating this restriction would be a sufficient deterrence.
Thank you, Evan. I appreciate that.
Could I follow up on that, Senator Sears?
Sure. Yep.
So Evan, would this be the same for a flip circumstance where a victim, it's in court and a victim puts on the public social media or wherever it is, that this was the offender, I was offended, this was the offender, and he's been charged and he's, I mean, I know that it only takes, so the victim actually gives the false statements. And I know that it only takes one sentence on either side to sow discontent and to get something out there. And it is almost impossible to refute things like that once they're out there, even if the attorney's made a statement. But would it apply also in that situation?
Well, to a certain degree, yes, but there's some differences that we have to keep in mind. The first difference is that already under existing law, defendants who are subject to a delinquency or youthful offender proceeding already have a greater ability to make public statements than victims or the state. And the idea is that the confidentiality provisions were structured primarily for the defendant's benefit. So if they want to waive those, they can do so knowingly because the benefit is for them rather than the confidentiality benefiting the state, for example, or the victim, for example. So they already have a greater ability to communicate about this stuff in public. That said, if they decide to do so through their attorney is already bound by this same standard in the rules of professional responsibility. And then the last sort of nuance that we have to keep in mind was one that actually Attorney Paul flagged earlier, which is at least according to the Defender General's reading of the law, victims can talk about their victimization more publicly than they can talk about what is actually occurring in the court proceeding. So, for example, a victim might already, under existing law, be able to post to their Facebook profile, so-and-so sexually assaulted me the other day, and whatever else they want to say. And if they don't divulge what actually was occurring in the juvenile proceeding itself, they may not be running afoul of the law. So there's some nuances there. But the state's attorney's offices would like to see some changes related to confidentiality and victims. For example, the issues that the center and the network identified regarding compensation and restitution programs, and making sure that those programs at least have access to the information they need to process those claims on behalf of victims. And I think that that's probably something we can accomplish without necessarily making that information publicly accessible. Something else that I think that we could probably do is clarify that point that I was just talking about, what victims can and cannot say publicly, and their fear that they might be subject to prosecution themselves for talking about their experiences. And in our proposal, we identify this at least one statutory section that might need to be looked at by way of an amendment. But for states' attorneys, it's very important that victims be able to talk with their mental health and medical treatment providers about what happened to them, their attorneys, and then also their other support networks. It's fantastic that we have victims advocates for them to tap into, but talking with your spouse or your parent or some other close family member might provide a level of support that cannot be provided by a victim's advocate who may still, relatively speaking, be a stranger. I know there was some conversation during earlier testimony about how, juvenile defendants might not be the same as adult defendants. And that's the reason why we have these confidentiality provisions, and the state's attorneys don't dispute that. But that same distinction may not be true for victims of adult offenders versus victims of juvenile offenders. And, those victims may still need the same support and treatment. And we need to make sure that whatever well-intentioned confidentiality provisions we have don't make it more difficult for victims to get those services. Another topic that we might be able to address on the short term is either clarifying or supplementing the public safety standard that currently exists in law for when youthful offender status might be granted. And the state's attorneys in their proposal have outlined some additional factors that may be, I would say it's a non-exhaustive list of factors. The idea being if some factors are identified in statute, when judges turn to statute, will it give them a better layout of the types of things they should be considering? So, for example, the nature of the charges, the alleged charges, the circumstances in which they were committed, the input of the victims, the results of any risk assessments that might have already been conducted, the impacts of a confidential designation on victim and public safety, and also the public's interest in the adjudication of the charges, which is obviously going to be more relevant for highly concerning serious offenses than it's going to be for lower level misdemeanor offenses, as an example. One issue that I've hinted at already is treating similar topics similarly. For example, when it comes time to figure out what we're going to do with a fully resolved delinquency proceeding, the default is to seal the records if someone is successful or if the petition is withdrawn. Whereas for youthful offenders, the default position is to expunge them. Why we might want to seal one set of records and expunge another, I'm not aware of a policy rationale for that distinction, but perhaps we can take a look at making topics like that more uniform throughout the two types of proceedings.
Actually, that was one of the reasons that was in youthful offender status, was because if you were a youthful offender and you designated as youthful offender, one of the benefits of that designation is if you successfully complete the program, you successfully do all the things that are required of you, then you would no longer have a record because it would be expunged. And we felt at the time when we wrote that statute that was a huge benefit compared to those who weren't amenable to treatment, or those who refused to do it, or those who failed during their youthful offender programming. They had to go back and face those charges. So it was kind of put in as a carrot rather than a stick. And I think I know exactly why it was there and why it was different. And the ceiling has always been there, but I've never been clear about what's actually sealed and what isn't. I ran into a case several years ago where a kid that I'd had in my program, who I had for over a year, I was very confident in him, and then he had the opportunity to come to work for us about 10 years later, but his name was still on the abuse register. And they said, well, he can't work there because his name's on the abuse register. I said, well, we're fully aware of why, but how did he end up? There's all his records are sealed because he was a juvenile, but somehow he's still on the abuse registry. We finally resolved the issue, and they looked at it and said, yes, that was, So it just it wasn't a sexual abuse case, by the way, it was a physical abuse. So we were able to resolve that, but it was kind of odd too. Yeah, of course we're aware of it. We wouldn't have, he was with us for over a year, and 10 years later, you can't hire him. Anyway, I'm not sure what sealing actually means anymore.
Well, and I think that's, I mean, and you know, Senator, that's a question that the Joint Legislative Oversight Committee is currently trying to explore,
Right.
and I anticipate both this committee and House Judiciary will also be exploring it.
That's the history of why why their youthful offenders are expunged if they successfully complete whatever programming, as well as deferred sentences are expunged too.
Yeah, and I certainly appreciate that history, and the state's attorneys are supportive of the concept that, you know, someone who successfully completes youthful offender probation should really have an opportunity to walk away with as clean a record as possible, so that they can move on with their life as this system is designed to permit them to do. I think what we're asking is, if someone is equally successful in completing delinquency probation, should they have at least an identical opportunity? And so that there's parity between the two proceedings, seeing as they're both designed at creating a rehabilitative process that allows someone to move forward with their life afterwards. And it's a policy decision, really, expungement versus sealing. I know that I've been on record saying that the state's attorneys have a preference for sealing, but I think what we would like to see at least is some consistency as much as possible on issues such as this amongst delinquency and youthful offender proceedings. But it's a question
also,
that
on your number two, number one, the insufficient number of secure placements. I wanted to point out that we did discuss that. Evidently, it's a federal law in terms of transferring this came up really because of Sununu being in New Hampshire and trying to place a very dangerous individual in a secure placement with the lack of Woodside. And my understanding is it's a federal law and that can't be circumvented, but, you know, we hope that they could get emergency hearings done with the courts. So we did look at that.
Yeah, and I think it's one of those situations where this process that we are now navigating because of Woodside has, in some situations, made things more difficult. And we've done a good job, I think, partnering with the sheriff's offices and DCF in addressing those issues where we struggle to find a placement, but they do still happen frequently. I think that the facility that's going to go online in Newberry is going to help address this issue. But my understanding, based on previous conversations with DCF, is the population that's the most difficult to find a secure facility for are the youthful offenders aged 18 to 20. And I recall that there may also be difficulties in finding placements for females. And that's because some of the facilities that we can access might have age-related or gender-related restrictions on who they can house.
The next witness is Sean Brown, the commissioner of DCF. He may be to expand on that, but I do think that you're correct. There was at one point 4 beds at the Rutland Correctional Facility for under 18 who had committed serious crimes. And because of federal rape elimination laws, they had to be separated by sight and sound. And they were in this 4-bed unit, and I don't know what the status of that is right now, whether that could house the 18-year-old dangerous. I wanted to mention one other thing in your, I don't know how to solve the age gap problem. Somebody turns, 18 and or 19, and they're one day before their 18th birthday, or they're one day after their 19th birthday. That's been an age-old problem, and you just don't have the time to work with them. I'm not sure how to solve that problem.
And the state's attorneys don't have specific statutory language that they can recommend, but we'd be happy to work on it with other stakeholders.
I think it is a continued problem. Currently, somebody can stay in DCF custody voluntarily, but that's voluntarily. And many times don't choose to do that.
Yeah, and I think what the state's attorneys would suggest the legislature explore is restricting the age limitations to when someone is eligible to have their case transferred to a delinquency or youthful offender proceeding. In other words, let's have the age restrictions look at when someone can get into a proceeding rather than when they get kicked out of supervision. That way, if they get in because they committed this offense when perhaps their brain development prevented them from appreciating the seriousness or riskiness of their offense, let's get them in, and then let's allow them to remain in until they can complete their rehabilitative services. There would be a couple of ways to address that. One, we could just bump the age up even more and give them more time. In other words, so supervision could last until a later age, or we could just say we're not going to have a hard age cap on when supervision can last, and we'll give these folks the time they need to complete it. I think if under either option, we're going to have to explore a little bit DCF's current capacity to provide that type of supervision to these offenders, and whether or not at a certain age it makes, do they need more resources to do it? Or at some point, are they going to have to receive some level of assistance from another entity like DOC that might be more accustomed to providing adult supervision, even if the nature of the rehabilitative services was determined in the context of a juvenile proceeding? And so that's what we would like to see at least explored this coming session.
Kind of makes sense.
Another thing
that's part of why youthful offender is preferable in some of those cases, because it could be you have the dual custody of DOC and DCF. Right.
Another thing that we would like to see addressed, which we might have time to explore, and this is something that I've mentioned related to other topics, is this borrowing the listed offenses in areas that are not directly related to victim services. So for example, right now we have the Big 12 and the listed offenses. Every Big 12 is a listed offense, but not every listed offense is a Big 12. But we use them now in the context of juvenile proceedings to determine when certain things may or should happen. For example, when the state might be able to directly file a youthful offender proceeding. What the state's attorneys would like to see happen, and not just in the context of this conversation, but in others as well, is take a step back and stop borrowing listed offenses in other areas. Those listed offenses were developed as a way of highlighting cases where victims of certain crimes might need additional support or should be entitled to additional statutory services. And when it comes to conversations like this and expungements, it might be more appropriate to say, well, let's just take a look, let's do an inventory of offenses and figure out if there's additional offenses aside from the listed ones that should influence this specific decision point. For example, when the state can direct file a YO proceeding. Something small that we might be able to address is the express authority for a judge to order a psychosexual evaluation of a juvenile offender for the purposes of determining what might be an appropriate probation condition, or what services might be most appropriate. And then the last topic that I wanted to address, which is something that both State's Attorney Marthage and I touched upon last time we testified, was the procedural ping pong matches that can result occasionally. The example that State's Attorney Marthage flagged the last time she testified was a case in which she felt as though a youthful offender designation would be appropriate, But the only way to make that happen, because she didn't have the ability to direct file it, was to file the case in the criminal division, allow it to be transferred to a delinquency provision, and then moving the delinquency back to the criminal division and filing a youthful offender petition. So there was, you had to go to 2 different courts. You had to transition twice in order to ultimately get to the status and in the court that you wanted it to be in. The state's attorneys have suggested that one way to resolve some of this ping-ponging would be to allow youthful offender proceedings to take place in the criminal division. I think that, another option that I think State's Attorney Martha touched upon also is just looking at the standard for when the state's attorneys can direct file a youthful offender petition. I think the state's attorneys have expressed a preference for the first option, having the venue of youthful offenders proceedings be the criminal division. But it's possible that a constructive solution could also be had by looking at the circumstances in which direct filing can occur. So those are the areas that I was hoping to cover from the proposal this morning. And I don't want to interrupt Commissioner Brown's testimony too much, but I am available to answer additional questions if folks have them.
Well, we may have those questions after the lunch break at noon. So I'm going to move to Commissioner Brown now, and hopefully you're available after when. I think we'll probably get started about 1:15. Because some of us have a caucus to go to. So Commissioner Brown, you have with you members of your team, and sorry for keeping you waiting there, but.
Yes, good morning. Thank you for the opportunity to be with your committee this morning and with the other witnesses. Senator, as to share with the committee, we spoke last week. We have not submitted specific legislative initiatives to the committee yet, notwithstanding the request to have those submitted by November 4th.
I'm having trouble hearing you, Commissioner. I don't know if others are.
Can you hear me now, Senator?
So, can you try again?
Yeah. Can you hear me now, Senator?
Yes.
Okay. As I indicated last week when you and I spoke, the administration, we're still working through and finalizing our proposals, legislative proposals. So we were not able to get them into the committee by November 4th. We're hoping to finalize those in the coming days and then utilize the juvenile justice stakeholder group to review those and to get their feedback and understand where there's consensus on our proposals and where there are concerns. So those could be highlighted when we share those with the committee to be included in whatever legislation that moves forward in this area this session. We share the goal to whatever moves forward to do so as quickly as possible during the session.
When do you think would be if the committee were able to meet again in December sometime, would that give you enough time to have your proposals ironed out?
Yes, if you were able to meet maybe mid to late December, that we should be able to have information to share to the committee by that time frame.
I think we could arrange that. That would give Eric some time to kind of put together some of the other proposals too, where there's been general agreement. Committee, any thought? Go ahead.
And then I was going to say, in listening and reviewing the proposals from Jessica and Jennifer, we are supportive of the changes they're seeking. Obviously, as we work through the details are always the matters to be resolved, but we do support the changes they're seeking in concept and look forward to working with both organizations and also the committee to move their proposals forward. Also, there's proposals shared by Evan that we support, and others I think that we need to understand a little bit more deeply. Many of these are procedural changes, as I think has been discussed here this morning in the committee. Ours will be some substantive changes to make improvements, what we think are improvements to youthful offender and raise the age. We're not looking to substantively move away from either of those policy initiatives. We still support those. As I've indicated, we do have a growing body of case experiences, which give us pause in terms of the level of dangerousness of some offenders that we're being asked to work with, that I believe are outside of the expertise and the capability of the department to manage those situations. And the difficulty we have in sharing those experiences with the committee is due to the confidentiality. And so we're open to having an opportunity, if possible, to share those in a confidential proceeding with the committee, so you can get a better understanding of what's informing some of our proposals that will be coming before your committee. But we certainly have experiences. To Senator White's question earlier to Jessica, are we seeing more dangerous cases coming to raise the age and youthful offender? And my answer to your question, Senator, is yes. And we have some specific case experiences that we'd be happy to share, but due to the confidentiality of some of the proceedings, we were not able to share those in open committee.
Yes, I'm not sure what the process would be to have an executive session of the committee to hear some of the concerns about the dangerousness of certain individuals. Do you know, Senator White?
We can do it. We have to have it's hard. It's really hard to do. What we found when we wanted to have one in GovOps is that the best advice we got was that just a couple people from the committee would meet without having a quorum, because it's really difficult and hard to justify. But I did have a question for the commissioner that you indicated that there are more serious people with more serious offenses coming into the youthful offender program, but Marshall seemed to indicate that the seriousness of the offense did not necessarily translate into the I don't want to call it not rehabilitation, but of the person, and that they had some very successful people with pretty serious offenses going through the youthful offender program and getting services and coming out as productive members. So while there are more serious ones necessarily, that doesn't necessarily indicate a failure of those people in that program. That's what I heard anyway.
Yes, and I think, as we've approached this issue and testified more recently on this topic specifically, Senator, that's why we're looking at, is there a way, instead of looking at listed crimes or Big 12, is there another type of assessment we can use to evaluate whether there's a level of dangerousness and amenability of treatment that makes youthful offender appropriate or inappropriate given the specifics of that case? And I think that's how we're approaching it with our thinking, is not looking at it that there's a list of crimes or not that make you eligible or ineligible, because I think it can go both ways, to be honest with you. There may be someone who was charged with something serious, but that it may be completely appropriate for that individual to come through youthful offender or raise the age, and we can have very good outcomes. Or there might be other youth or emerging adults that are not appropriate based on concerns we've had and specific examples that we could share. And that, we are concerned about our ability in certain cases to manage youth, emerging adults under certain statuses and maintaining public safety. And I think that directly leads to the earlier conversation regarding secure placement. And, youthful offender is really a community status. And so if you have someone on youthful offender status who's risen to the level of dangerousness, I think that goes to, what we're speaking to, which is if someone's to the level on youthful offender that they need to be in a secure placement, we believe they're no longer appropriate for youthful offender, or should not be considered for that, and should be in an adult system.
But could somebody who commits or is alleged to have committed a relatively minor crime could be just as dangerous? That's the problem you just outlined, as somebody who committed a very serious, or is alleged to have committed a very serious crime.
Yeah, I think what we're looking at, Senator, is not listed as what someone's charged with, but their behaviors, and then what an underlying assessment may show whether they're going to be successful. There's a level of dangerousness there that might not be evident from what they've been charged with, and I think that's why we want to approach it from that lens and not from a listed, crime, whether this might be a minor crime or this was a serious crime, but that we have a tool available that can do this assessment, so that we're making sure emerging adults are getting served in the proper system.
I understand. My concern is the variation to justice in various districts. So what appears to be a serious offender in Bennington County may not be as serious in Chittenden County or Windham County. And I would be concerned about some kind of uniformity in whatever we establish, which is where risk assessment might come in. I realize you can look at a long criminal history, but over the years, I was just talking the other day about some kids I had in the program, and 3 from the same family. One who looked very dangerous, but probably was the most successful that left the program. And the other 2 may not have looked as serious, but they were very serious and were unable to really deal with. So it varies so much, and you hope that risk assessment can actually give us the best information about dangerousness. And then amenability to treatment is the other area, and that's why I was asking Marshall about that and others about amenability to treatment and how we characterize that. How do we look at that?
I agree, Senator. I think there is some variation that we see across how youthful offenders applied in different jurisdictions and the outcomes that we see. And we believe if we had an assessment tool to rely on, that could address some of the inconsistencies and lead to more equitable outcomes across the state.
Either Tyler or Katrina, any comments on your part?
I just like to, I appreciate this line of conversation. Oh, sorry, this is Tyler Allen, Family Services Division, Adolescent Services Director. I appreciate this conversation greatly. And I think the only thing I would like to add to the testimony from Commissioner Brown relative to the conversation we're just having is that the amenability to treatment question that you keep bringing us to, Senator Sears, I think is a very good one. And in my mind, part of, as we talk about what assessment looks like, we're thinking about what are thorough assessments that tell us things that are useful. And if we have cases where we don't know, there is not recognition of crime or something like that at the point of assessment, is our assessment complete? So I think that's why some of these ongoing conversations around how do we assess in a way that is thoughtful, that is grounded in statistics and evidence, and we want to ensure that any assessment protocols or practice used are not misused, so to speak. So I think that's why some of these conversations go together. And I wanted to appreciate also the state's attorney conversation around the number of factors that lead into assessment and making some of these determinations. Sometimes the assessment is just one piece of the puzzle. And I think in many of the conversations I've heard around assessment in general is that you're compiling a lot of contextual factors in turning out an assessment that is comprehensive and therefore useful.
Thank you.
And then the other thing I'd like to on Senator Sears mentioned, some of the challenges, and I think Marshall spoke to this as well, that our system of care are experiencing. And for sure, we are seeing the impact of COVID-19 virus on our system of care, directly having outbreaks in some of our programs, and particularly with staffing, but also the workforce challenges that are coming that we're seeing in the workforce now in terms of being able to retain and recruit workforce. And we're working hard to address those. We've actually had some of our family services staff working in programs recently to help shore up staffing to make sure that they can continue to provide services to youth there and not disrupt their care and treatment. We're also working to leverage some traveling healthcare resource contracts that are being used elsewhere in the Agency of Human Services in the state to provide some traveling resources to some of our programs to make sure that they have staffing available to help meet the needs of the youth in the program. We're also utilizing financial resources from the Healthcare Stabilization Fund currently for some programs to make sure that they remain financially viable and can meet the increased costs that they're experiencing with some of the staffing challenges that they're having, and then also using the extraordinary relief process under rate setting as well to help support those programs. So a lot is happening on our end to address those. Notwithstanding, there are a lot of challenges across our residential system of care, and we're working hard, but I think it's going to take some time for those to stabilize and then build back up as we see an end of the hopefully soon.
Can you work with Eric Fitzpatrick and myself to come up with some of the information that we need so we can establish a fifth meeting of the Judiciary Committee to try to solve this? So probably Senator White's suggestion meet maybe in smaller groups rather than try to put together an executive committee meeting. An executive session might be difficult, although I have no objection to that, but I'm not sure what we would get.
Sure, we're happy to work with Eric from.
Maybe you and I can talk further about that. I think I have a sense of the dangerousness of some of the kids that we're seeing, but I also have a sense that it isn't always what it seems. Anything else, Mitty, before we break for lunch and then get back at 15? Eric, are you good?
Yep, all set for now, Senator Sears. Thank you.
Thank you. So we'll take a break until 1:15